second part of the webinar series. My name is Gilbert Wesso and I'm the Chief Researcher in the Research Unit, which is located within the Knowledge and Information Service.
Recording in progress.
Parliament. Ms. Hubrecht from Unicef and I will be your program facilitators for the webinar dealing with government's treaty and development responsibilities to children and Parliament's role in ensuring compliance. I will introduce staff from Parliament and Ms. Hubrecht will introduce the UNICEF country reps and presenters. At the end of the program, I will do the vote of thanks, but before we start, a few protocol matters to take note of. Number one, please raise your hand on the Zoom platform when you wish to speak. Secondly, cameras should remain off and microphones on mute unless recognized to speak on the platform. Thirdly, please switch your camera on while speaking. Number four, please identify yourself when asking a question. Fifthly, question time will be allowed for 5 minutes after each presentation. Also use the Q&A and the chat options on the platform to raise questions if needed. Number six, presenters should please stay within the time slots provided in the program. And finally, presentations will be available on a link which we will be making available to all webinar delegates. Now, before we start with the program proceedings, we wish to say a heartwarming welcome to Honourable Nkongeni, as well as the other Honourable Members of Parliament, the Department of Social Development, the Department of International Relations and Cooperation, senior staff from UNICEF, Stats SA, the Children's Institute, the African Civil Society Coalition for Children's Rights, our senior managers from Parliament, and last but not least, our most esteemed program participants and presenters. I'm now delighted to introduce our first speaker, Ms. Muriel Mafika from UNICEF, who will do the opening and observations from day one. Over to you, Ms. Mafika. Thank you.
Good morning. Thank you very much, Dr. Wesso, our program director for today. This is really a delight for me to join you. Allow me to also extend warm greetings to the Speaker of the National Assembly in absentia, the Chairperson of the National Council of the Provinces, Chairpersons of Portfolio Committee on Social Development and the Select Committee on Health and Social Services, our dear partners who are online and those yet to join, distinguished guests, ladies and gentlemen. It is a great honor and a privilege to open this webinar on government's treaty and development responsibilities to children and Parliament's role in ensuring compliance. I am delighted to join you this morning. I wanted to start off by congratulating Madam Speaker for this webinar series. As Honorable Masando reminded us last week, this webinar series marks the first multi-sectoral engagement of the 6th Parliament, focusing on the rights of children. Thank you to Madam Speaker and all the people who have been part of this webinar series for making it a reality. Sincere gratitude also to all the government departments and civil society partners who have worked tirelessly to prepare the materials that have really set the tone for the discussions that we are having in this webinar series. This is really a true product of collaboration and collective commitment to children. This series of webinars and the follow-up actions have really created a space to deliberate the role of Parliament and also to focus on the importance of using knowledge to support Parliament in performing its functions. The presentations from the first webinar helped to set the context and to outline the situation of children in South Africa. I personally had the opportunity this weekend to listen to the entire webinar and all the amazing presentations that were made last week. I really appreciate, and I'm sure everyone who is part of this webinar appreciates the rich and well-researched information which was shared and will therefore form the basis of the discussions today. We also were able to learn from those presentations the progress that has been made, but also the unfinished business that is still before us. Allow me to share some of the brief observations that were made at the end of the webinar last week to provide a bridge and also to serve as an anchor for today's webinar. Last week, during the presentations, a number of issues came up which warrant repeating. First of all, from the Honorable Speaker opening remarks, it was very clear that the legacy of apartheid cannot be ignored when we are looking at the current situation affecting children and when we are looking at the future interventions that are needed to redress the impact of that legacy. So in her opening remarks, she really set the context and outlined how the architects of apartheid had succeeded in eroding the very institutions and fabric of society. It was also very clear that the policies at that time were designed to cripple the development of children and to start and sustain an intergenerational cycle of disempowerment and exclusion, which was based on race, geography, and income. This legacy, therefore, is what we see today. Despite the adoption of many proper development policies, and South Africa is very well known for progressive policies, state-of-the-art policies. But despite these policies, it has been difficult to reverse the damage that was done. And therefore, if we are to rebuild the environment and empower parents and caregivers to provide a nurturing care, it is important to fully address the impact of those legacy issues. Another aspect which emerged from last week was the sober reality. The sober reality that today South African children face a number of challenges. They face a number of development challenges. This was evident from the data that was shared by many of the presenters, from Professor Nick Spall to Stats South Africa and the Children's Institute. Some of the key messages that came up are as follows. About 62% of children in South Africa are classified as multidimensionally poor. That is a huge challenge. We also heard about widening inequality, and this in part is amplified and compounded by COVID and its impact. Then another staggering statistic was that of hunger. The fact that 10 million people in South Africa, at least by May of this year, had reported that they were experiencing hunger. And then another 3 million children as well was also reported to be living or experiencing hunger. These are huge numbers. These are huge challenges that require urgent attention. The issue of unemployment is well known to everyone. The figures are also staggering. And then, of course, the loss of livelihoods. So all these issues were highlighted last week, and they really set the tone in terms of the magnitude of the issues at hand, and therefore the importance of a multi-sectoral, transdisciplinary approach to addressing these issues. What was also clear from the evidence shared was that the vulnerability is experienced by some groups. So, for instance, the data that was shared showed how African children are experiencing unique challenges and disadvantages. And then also the issue of children in rural areas and former homelands. It was clear that if we fail to address these issues and really ensure that we give every child the best start, we will actually have a situation where children will not reach their full potential. So there is the urgent need to break the cycle which perpetuates intergenerational cycle of poverty, and making sure that we really empower the communities, the families, and the children. And in fact, one of the issues that was highlighted also was that according to the Human Capital Index, in South Africa, a child is only able to develop to 48% of their full potential because of all these multiple deprivations that children are experiencing. So clearly, this calls for urgent action. Having discussed these challenges, I think it was also very clear that there are opportunities in crisis. It was clear that there are silver linings. Allow me to highlight some of the silver linings that were flagged. The first opportunity was that of investing in early childhood development and ensuring that we have a strong foundation on which we can build the South Africa we want. This was supported by data that was also shared by Professor Nick Spall. The second opportunity was the demographic dividend, which was highlighted by Stats South Africa. South Africa has a youthful population, which is a tremendous resource for development, for inclusive and fair development. Children and young people have a key role to play. And as Honorable Mvana reminded us as well, children need to be given space for meaningful participation. This is absolutely critical. The other opportunity which came up was how we can use the recovery from COVID to set the stage for a more equal and inclusive recovery by putting children and young people at the center of COVID-19 recovery. Lastly, on the opportunities, the fact that South Africa has globally admired policies, which are very progressive, and the country invests significant amounts of money from the budget into social services. So these are opportunities at hand, which we can maximize. But as highlighted by the presenters, there is urgent need to break down silos which adversely affect coordinated approach and maximizing of resources. Indeed, the presentation by the Office of the Rights of the Child underscored coordination, strengthening of institutional mechanisms, and mainstreaming of child rights as key imperatives in order for us to really maximize the opportunities that we have. And then the other aspect that I would like to highlight, which came out clearly last week, was the importance of implementation. The fact that, yes, we have these progressive policies, but implementation of the policies is absolutely key. So building on the foundation that was set during the first webinar, today provides an opportunity to further explore child rights governance and the role of various stakeholders. This webinar is very timely. In fact, it comes just a few days following the commemoration of the anniversary of the Convention on the Rights of the Child, which was done on the 20th of November. There is no better way that I can think of commemorating the Convention on the Rights of the Child than having, by having this kind of webinar, which brings together so many stakeholders who play a critical role in making the CRC a live instrument that translates into changes for children. And as we were reminded as well by Laurie Lake last week, many things we need can wait. The child cannot. I think this says a lot about the sense of urgency with which we come to this webinar series. Indeed, the decisions and actions we take have a huge generational impact. Let me conclude by reaffirming UNICEF commitment to continue working with Parliament and all the partners in ensuring that we give every child in South Africa the best opportunity to reach their full potential. Thank you very much. Over to you, Dr. Wesso.
Thank you, Ms. Mafika, for your opening remarks, which highlighted some of the important issues discussed on webinar 1. I think your remarks certainly provide a solid bridge and anchor for the webinar this morning. So with that, I will now hand over to my colleague, Ms. Hubrecht from UNICEF, who will kindly introduce and moderate the presenters from UNICEF, country reps. So Madam Facilitator, over to you. Thank you.
Thank you so much, Dr. Wesso, and thank you so much, Maria Mafiko, our Deputy Representative. So after we have recapped on last week's webinar in terms of the roles, responsibilities, the importance of child rights governance, today I am very honored to introduce to you a series of very renowned speakers, high-level representation in society, that to really look at the government's treaty and development responsibilities to children and Parliament's role, especially in ensuring compliance, strengthening of the system and responses by addressing the data deficits. So in the first session this morning, we have Ms. Natabi Singh Malefane, the Director for Vulnerable Groups from our Department of International Relations and Cooperations, DIRCO, and Mr. Jean-Baptiste Foucault, the Human Rights Officer from the Office of the High Commissioner of Human Rights. And both will explain to us the overview of treaty and development responsibilities on the state with an implementation through a child rights governance system. So our first speaker this morning is Mr. Foucault, and Jean is a human rights officer with OCIHR, the Regional Office for South Africa. He leads the work of the Regional Office in terms of providing technical support, guidance, and advisory services to government stakeholders, national human rights institutions, civil society, and the UN country teams in the sub-region in order to engage with United Nations human rights mechanisms. It's an honor for us, Jean, to welcome you, and good luck with your presentation. We look forward to receiving it.
Thank you so much, Michael, and good morning to everyone. And for the sake of time, all protocol observed. Michael, I have tried to share my screen, but I can't. It looks like I am disabled. Is it possible for me to share my screen, please?
Yes, Tiamo will do it.
Thank you.
Please go ahead, Mr. Foucault. Just tell him each time. Next slide, please. Thank you.
All right. Thank you so much. My presentation is going to focus on an overview of South Africa's treaty obligations and the role of Parliament in promoting implementation. Next slide, please. But before getting into the crux of the presentation, I would like to touch briefly on what do we mean by human rights? What are some of the key elements to take into consideration when we speak about human rights? I think the first point that we need to look at is the fact that human rights is inherent simply by the fact that we are humans. So it forms part of our inherent existent as human beings. The second point that I would like to touch on is the fact that human rights are inalienable. Here, what I mean is that human rights cannot be taken away, but there are certain exceptions. And when those exceptions apply, it has to be done mindful of due process of the law. The third point that I would like to touch on is the fact that human rights are universal. So irrespective of where we are, we have to be able to enjoy our rights. The next point I want to also mention, which is linked to the last, is the fact that human rights are indivisible and they are also interdependent. We cannot enjoy civil and political rights without enjoying economic, social, and cultural rights. So they are indivisible and they are also interdependent. I'd like to touch briefly on the UN human rights system. In the UN human rights system, we have the treaty body system, and then we also have the Universal Periodic Review, which is a system that provides for the review of the human rights record of UN member states every 4 years or 4.5 years. And South Africa is going to be going through the fourth cycle of the Universal Periodic Review in 2022. Then you also have the special procedure mandate holders who are independent experts working under the Human Rights Council. But our focus in this presentation is going to be on the treaty body system, which is made up of 9 core human rights treaties. And South Africa is a state party to 7 of the core human rights treaties, including the Convention on the Right of the Child. Next slide, please. I think it is very, very important for us to look at the development of human rights standards. And I think the first crucial document that we have to look at is the Universal Declaration of Human Rights, which was adopted by the UN General Assembly on the 10th of December, 1948. Although this document is not a binding document, as the name itself denotes that it is a declaration, it sets out fundamental principles that has informed the development of so many international human rights treaties and also various national constitutions as well. But one point that I also want to highlight is that there are fundamental principles in the Universal Declaration of Human Rights that do form customary international law. So I would like to request for us to move to the next slide, please. As I mentioned in the previous slide, the Universal Declaration of Human Rights has led to the development of core human rights treaties. And as I mentioned, there are 9 core human rights treaties. And these are human rights treaties that are binding on state parties. And it is very, very important for me to please emphasize here that a state makes a voluntary decision to become a state party to a treaty. And you can become a state party to a treaty through ratification. That is when the treaty has been signed, and then you decide to take the next step to make it binding on you, then you ratify the treaty. You can also become a state party to a treaty through accession. The difference between ratification and accession is that ratification is preceded by a signature, but accession is not preceded by a signature. Accession applies when the treaty has already attained the required number of signatures and ratification, and it has come into force. Succession applies when 2 states, when there is secession and then one party of a state decides to succeed to the treaties that the previous body is a state party to. But one point that I want to please emphasize here is that becoming a state party to a treaty, a state makes an obligation under public international law to uphold and implement the provisions of the treaty. So this is very, very important. As South Africa is a state party to the Convention on the Right of the Child, South Africa has made that obligation under public international law to uphold and implement the provisions of the Convention on the Rights of the Child. Next slide, please. But it is very, very important for me to highlight that if you look at the treaties, which I am going to emphasize on in the course of this presentation, the human rights treaties do underline the three core obligations of the state: the obligation to respect, the obligation to protect, and the obligation to fulfill. What do we mean by an obligation to respect? It means a state is supposed to refrain from interfering with the enjoyment of rights. When we say a state has an obligation to protect, it means a state is supposed to prevent others from interfering with the enjoyment of rights. And one point I want to emphasize here, this also applies to non-state actors and the private sector. So if we are referring to the rights of children, the state also is supposed to exercise that obligation to ensure that non-state actors don't violate the right of children. The obligation to fulfill, here it means the state is supposed to adopt appropriate measures in terms of legislations, policies, budget allocation to ensure that treaties, laws are applied, are implemented at the national level. And these three core obligations are very, very fundamental when we talk about the obligations of a state in terms of treaty implementation. Next slide, please. So as I mentioned, once a state has become a state party to a treaty in question, the state must take steps to ensure that its domestic legislation is in conformity with the provisions of the treaty. In this context, when we are speaking about the Convention on the Right of the Child, it is very, very fundamental for South Africa to ensure that it has taken the necessary measures to ensure that its domestic legislations are in conformity with the provisions of the Convention on the Right of the Child. And then it is also supposed to ensure that it takes the necessary measures to implement the provisions of the treaty. But one point I also want to mention here that sometimes when a state becomes a state party to a treaty, it can do so with a reservation. This is when a state stipulates that it is not going to be bound by a particular provision of a treaty simply because that particular provision is not aligned with its national framework. And I'm going to give you the example of Botswana, which ratified the Convention on the Right of the Child. And I don't have a specific example in South Africa because South Africa did not ratify the Convention on the Right of the Child with a reservation, but Botswana did so. When Botswana ratified the Convention on the Right of the Child, it did so with a reservation to Article 1, because Article 1 defined a child as anybody who is below the age of 18. But at that time, Botswana had a national law that defines a child as anybody who is below the age of 16. So Botswana indicated that it was not going to be bound by that particular provision. But later on, Botswana passed a national law defining a child as anybody who is below the age of 18. So that reservation has to be withdrawn. Next slide, please. So as I mentioned, there are 9 core human rights treaties. And as I mentioned to you, you have the Universal Declaration of Human Rights, which does not form part of the 9 core human rights treaties, but it has helped significantly to inform the development of the 9 core human rights treaties. The first 2 core treaties are what we refer to as the 2 covenants. Here we are referring to the Covenant on Civil and Political Rights, and we are also referring to the Covenant on Economic, Social, and Cultural Rights. Then we also have additional human rights treaties that do focus on specific phenomena. For example, the International Convention on the Elimination of All Forms of Racial Discrimination, the Convention Against Torture, the International Convention on the Protection of All Persons from Enforced Disappearance. Then you also have human rights treaties that do focus on specific groups. For example, you have the International Convention on the Elimination of All Forms of Discrimination Against Women. Then you also have the Convention on the Right of the Child. And since our focus in this webinar is on the rights of children, it is very, very important for me to emphasize that the Convention on the Rights of the Child highlights 4 cardinal principles: the principle of non-discrimination, the principle of the best interest of the child, the principle of the right to survival and development of the child, and the views of the child. These are 4 cardinal principles in the Convention on the Rights of the Child. Then you also have the Convention on the Rights of Migrant Workers and Members of their Families, and you also have the Convention on the Rights of Persons with Disabilities. I just want to please emphasize one point. Although we are referring to the Convention on the Right of the Child as the focus of this webinar, it is important for us to be mindful of the fact that issues concerning children are not only articulated in the Convention on the Right of the Child, although it is a main human rights instrument that talks about the right of children. But if you look at other international human rights instruments like the Covenant on Economic, Social, and Cultural Rights, you can also articulate issues in relation to the rights of children in terms of health, education, water, sanitation. All those issues can also be related to the right of children. If you look at the Covenant on Civil and Political Rights, you can also articulate issues in relation to the right of children in the Covenant on Civil and Political Rights. Similarly, if you look at Convention Against Torture, Convention on Racial Discrimination, Convention on the Elimination of Discrimination Against Women, you can also articulate issues in relation to children in these conventions, and also the Convention on the Rights of Persons with Disabilities. So it is very, very important for state parties to be aware of the fact that it is important for them to also implement those other treaties that do have implication on the rights of children. In terms of the monitoring bodies, it is very, very important for us to highlight that as states have an obligation to implement these treaties are monitored in terms of implementation by specific treaty monitoring bodies. And as you can see on this slide, if you look at the names of the treaty monitoring bodies, it is almost a replica of the name of the treaty, with the exception of the Human Rights Committee, which is responsible for monitoring implementation of the Covenant on Civil and Political Rights. So these are the bodies that are responsible for monitoring implementation of the various treaties. Next slide, please. But what are their roles? What are the roles of these monitoring bodies? That is why when states have these obligations, these bodies have to exercise these functions to ensure that these treaties are implemented at the domestic level. The first function is that the treaty monitoring bodies have the responsibility to receive reports from states. When a state becomes a state party to a treaty, you can submit an initial report 1 year or 2 years, depending on the treaty, after becoming a state party, or you can submit an initial report 4 years or 5 years, depending on the treaty. So you also have the complaint procedure, you have the country visits, you have inquiries, which I am not going to focus so much in the course of this presentation for the sake of time. Next slide, please. I just want to mention to you that if you look at this slide, you can see South Africa's treaty obligation. South Africa is a state party to 7 of the 9 core human rights treaties. And South Africa has been doing relatively well in terms of reporting to the various treaty monitoring bodies, but I think there's still so much work to be done on implementation. Next slide, please. I also want to mention to you that in addition to the 9 core human rights treaties, South Africa is also a state party to a couple of human rights treaties within the African human rights system, like the African Charter of Human and People's Rights, the African Charter on the Right and Welfare of the Child, and additional treaties that you can see on this slide. Next slide, please. But as I mentioned, South Africa has an obligation to report to the treaty monitoring bodies on steps that the state is taking to implement the treaty provisions, and then the treaty monitoring bodies are also supposed to review the report submitted by South Africa and provide recommendations, and South Africa will have the obligation to implement those recommendations as well. Next slide, please. But I think it is very important for me to end this presentation by looking at the role of the parliament in the implementation of human rights treaties. I think the first thing that we have to look at is that the parliament has a role to encourage ratification of human rights treaties that have not yet been ratified by South Africa. So it is very, very important for us to look at this. And in terms of the Convention on the Right of the Child, South Africa is still to ratify the optional protocol on the Convention on the Right of the Child on individual complaints. So it is very, very important for the parliament to be mindful of the fact that it has a role to play to advocate for the ratification of the optional protocol on the right of the child to provide for individual complaints. The next point is that the parliament has a role to play in terms of exercising its oversight function by requesting the Department of International Relations and Cooperation and also relevant government ministries to update the parliament on steps that South Africa is taking in terms of reporting to the various human rights treaties and also implementation of the recommendations as well. The next point that I want to also emphasize on is that the parliament has a role to play to ensure that human rights treaties, the concluding observations are used as benchmark to scrutinize the drafting of laws to ensure that laws comply with the treaty that South Africa is a state party to. Next slide, please. The next point I want to also emphasize on is that the parliament has a role to play to ensure that there's domestication, which means that policies and laws have to be put in place aligned to the treaty that South Africa is a state party to. And the parliament is also supposed to ensure that there's allocation of necessary budget for the implementation of these treaties. Michael, if you could please just give me just 1 more minute, I can just finish this slide. I think it is very, very important for us to be mindful. Please, next slide, please. I think it is very, very important for us to know that the parliament has a very important role to play to ensure that measures are in line at the domestic level to ensure that the Convention on the Right of the Child is implemented. And I have already mentioned some of them, but I think it is important to ensure that the government carries out systematic process of assessing new laws, policies, and programs to ensure that these laws have impact on the rights of children, develop comprehensive national strategy or agenda for children based on the convention as well, provide adequate resources, and to ensure that budgets are aimed at also addressing concerns faced by children. And it is also very, very important for the government to ensure that there is development of a national mechanism that is responsible for coordinating, monitoring, evaluation of implementation of the various provisions of a treaty, especially the Convention on the Right of the Child, and also developing training, education, and capacity building for all those involved in the implementation process. Last slide, please. And it is also important to ensure that there is a creation of a mechanism or process to ensure that all state actors, here we are referring to the state and non-state actors, are involved in the implementation of the convention, and also promoting cooperation with civil society organizations, and also ensuring that there's development of adequate data that will be aimed at providing necessary information to inform implementation initiatives on the rights of children. And then I'll also end here by saying that it is important to ensure that it promotes international cooperation in terms of implementation of the Convention on the Right of the Child. Thank you so much.
Thank you so much, Mr. Jean Foucault, the Human Rights Officer from the Organization of the High Commissioner for Human Rights. We will now hear from Ms. Malefane what these international treaty obligations mean for South Africa, what the role is of DIRCO and line departments in that respect, and also the link to Parliament. Ms. Malafane, welcome, over to you.
Thank you very much, Maggie, and good morning, colleagues. Good morning, honorable members. Can you please load my screen, the slides, please, so that I can start?
We'll show your screen. We will show the slides, Ms. Malafane.
Okay. Okay, no, thank you very much. My presentation will actually just continue from where Mr. Fokker left off. I will zoom into the national processes of what the roles and responsibilities of government are, and particularly those of Parliament. Next slide. Just to give you a bit of background, the previous one, please. No, go back. Yes, thank you. Just to give you a bit of background, South Africa's foreign policy and its approach to international human rights law is guided by three main pillars. The first one is the Charter of the United Nations. The second one is what is called the United Nations Bill of Rights, and this consists of three major conventions, the Declaration of Human Rights, and the Universal Declaration on Human Rights, and then the International Covenant on Economic, Social, and Cultural Rights, as well as the International Covenant on Civil and Political Rights. And then also the Constitution of the Republic of South Africa is aligned to this. I can't stress that enough. Next slide. And when you look at South Africa's obligations within the UN Human Rights Treaty system, at the advent of our constitutional democracy in 1994, we were readmitted into the community of nations. And one of the first things that we did was to make sure that we accede to as many as possible of the conventions. And the implications of that accession to these conventions is that we had to make sure that we comply with our duties and responsibilities of the treaty obligations. I think Mr. Fokker has gone to a lot of detail in terms of what the responsibilities of state parties are. So I won't repeat what he said, but as a country, we have that responsibility that we make sure that we comply with the obligations of all the treaties that we are now state party to. Next slide. And then talking about our constitutional mandate, I mentioned earlier on that the Constitution is also one of the major pillars on which our foreign policy rests on. The Constitution gives the President the ultimate responsibility to conduct South Africa's foreign policy. And the President is assisted in this role by the Minister of International Relations and Cooperation, who assumes the overall responsibility for all aspects of South African foreign policy. And this includes coordination and formulation, and also looking at effective implementation. And all this is covered in the Constitution, especially the international agreements that are concluded in terms of sections 231 para 2 and 231 para 3 of the Constitution. Looking at the role of Parliament specifically, as I mentioned, the international agreements are in two sections of the constitutions. Those that are within the ambit of section 231 require parliamentary approval before they can bind the Republic. And these are mainly agreements that have financial or legislative implications, those that require ratification or accession, and Mr. Fokker explained this as well, and those that have political significance. So these first have to go to Parliament for approval. And then an international agreement only binds the Republic after it has been approved by resolution in both the National Assembly and the National Council of Provinces, unless it is an agreement that falls under Section 3, because those are of a technical nature and therefore they don't go to the two houses in advance. And then also another important factor to mention is that an international agreement needs to be enacted into law and become part of national legislation in order for it to be implemented. Next slide. The process of ratification for international treaties. The agreements that require ratification or accession, I spoke about this earlier, are those that fall under Para 2 of Section 231. And they need first the approval of the National Executive, the President and Cabinet Ministers, and then thereafter they go to Parliament, which must also approve that the country can ratify or accede to these agreements. And then the agreements that are of a technical nature are covered under the ambit of Section 231, Para 3. And this, although they don't require parliamentary approval, they are then usually tabled in Parliament after signature for noting. Next slide. And when tabling the agreement in Parliament, usually you find that the process is that the minister that is responsible should then formally write to Parliament, to the Speaker of the National Assembly, as well as to the Chairperson of the National Council of Provinces. And this letter must clearly indicate that tabling is in terms of Section 231, Para 2 of the Constitution. It must also be accompanied by what we call an explanatory memo, which will set out the history, the objectives, and the implications of the agreement. And also a draft resolution must accompany the tabling of the agreement. And all of this then have to be discussed and approved by Parliament. The agreement usually goes to the relevant portfolio committees and houses of Parliament, and then it will be printed in the announcements, tablings, and committees resolution. And then the reports of the committees are considered, and then the last step is that the approval is printed in the minutes of the proceedings. Next slide, please. And when looking at South African treaty obligations, our first obligation is to compile national reports. All the treaties that were mentioned earlier by Mr. Fokker have got an obligation that the state party should report on a regular basis on the implementation thereof. So the first obligation is that we compile national reports to the relevant treaty monitoring body, and this talks to the implementation, and then the treaty body will usually then come up with what is called concluding observations following the presentation of the report. And these concluding observations usually highlight areas where perhaps the state party is not doing as well as it should be, or areas that were not clear in the national report and things like that. And the compilation of process to cover for these national reports, the attempt is to cover the width and the breadth of the country to make sure that the report is inclusive and also that it is consulted with all stakeholders. And then the report must also focus on actual implementation of the provisions of the relevant treaty. And the content of the report must also address the existing protection gaps and a vision for filling of such gaps. And one other obligation that we have as a state party is to make sure that we support the work of the treaty committees by responding positively to requests for information or requests for visits and any other requests that we may get from the treaty body. Now, focusing on the obligations for child rights, South Africa has an obligation to submit progress report on the realization of children's rights and well-being in both the United Nations Committee of the Child, on the rights of the child, and also the African Committee on experts of the rights and welfare of the child. The Unconventional Rights of the Child was ratified on 16 June 1995. It was one of the first ones that was ratified, and we submitted our initial report in July 1997. And the concluding observations were received. At the moment, we are working on the next, which is our third report, and this is due in January 2022, though because of COVID and the difficulty in getting inputs from all stakeholders, the committee has now extended this deadline to June 2022, but I'm happy to report that work is proceeding well on this aspect. In fact, I think even for January, we have been able to meet the deadline, but we appreciate the extension. So our sixth report will be even more comprehensive. Next slide. And then the Convention on the Rights of the Child has got 3 optional protocols. This was also mentioned earlier on. The optional protocol on the sale of children and child prostitution and child pornography. This we ratified in June 2003. The initial report was submitted in 2005. And then the concluding observations were received in 2016, and the next report is also due on 15 January 2022. So this as well is something that government is currently working on. And then we have the optional protocol to the Convention on the Rights of the Child on the Involvement of Children in Armed Conflict. This as well, we ratified it in September 2009. The initial report was due in October 2011. And unfortunately, we haven't submitted a report, but it is also because South Africa does not have armed conflict, which is a good thing, I guess. So we haven't been able to submit a report in this instance for this particular optional protocol.
Ms. Malafan, can we kindly wrap up, please? Start wrapping up.
Oh, okay, I'll try and speed up. And then the last optional protocol is the one that it was mentioned that we have not yet ratified this optional protocol, but we are working with the Department of Justice, and there is general consensus that South Africa should accede to this optional protocol, and it's on the communications procedure. And the reason that we had not acceded to this one was because there was a feeling initially that national legislation covers the complaints procedures adequately. Next slide. Just to touch on the challenges before I conclude, the challenges that we have is that the reports at the moment, some of them do not adequately address the protection implementation gaps. And as I indicated earlier, this then leads to a lot of concluding observations that ask questions that were not adequately addressed in the report. And then also the lack of available data, and that specifically demonstrates the status of child rights in the country. But I think this webinar and what Unicef is doing will assist in this regard, that we get more up-to-date and more reliable data. And then also line function departments tend to revert issues of child rights to the Department of Social Development. And unfortunately, these are cross-cutting, and it's not just social development that has to deal with child rights. And this sometimes raises gaps, because we find that some departments feel that this is not their primary responsibility. And then last but not least, the limited resources in the Office on the Rights of the Child to effectively coordinate everybody government-wide and at all spheres of government. That is the one challenge that we also experience. And I would like to thank you very much. I will stop here. Thank you.
Thank you very much, Ms. Malefane, our Director for Vulnerable Groups at the Department of International Relations, with more than 20 years of experience in public service, including 17 years as a senior manager in DIRCO. So there you have it, participants, dear delegates, the situation of treaty and development responsibilities of the state. I believe that both presentations were very comprehensive and succinct, explaining what these are. For your information, all the decks of slides will be shared with all participants and beyond in order to have it at hand. Also, this session is being live streamed on YouTube. So, as there is no time for questions and answers, please start writing all your questions in the Q&A so that we can address them while we continue. And for that matter, I would love to introduce Professor Anne Skelton, who is Professor of Law at the University of Pretoria. She worked as a children's rights lawyer in South Africa alone for 30 years, and her global influence has been recognized through the Juvenile Justice Without Borders Award, which she received in 2017, and her involvement as chairperson of the advisory board of the UN Global Study on Children Deprived of Their Liberty, and being appointed as an ambassador for the British Society of Criminology. Professor Skelton is currently a member of the UN Committee on the Rights of the Child, having been elected there in 2024, second term in office. So Professor Skelton, we look forward to receiving and welcoming you and listen to your comprehensive presentation on the system of reporting to the Committee on the Rights of the Child and the upcoming list of issues that are in need to be addressed. Over to you, Anne. Thank you.
Thank you very much, Micah. It's been a pleasure listening to everyone so far, and it's great because there's now a very good background so that I will be able to show mine. Could the organizers please allow me to share my screen? It says that it's disabled.
Rudy, can you please give Professor Skelton the right to screen her screen? Thank you.
Will do.
Professor Skelton, are you able to show your presentation?
Unfortunately, I'm still getting a notice that says host disabled, participant screen sharing.
Rudy, over to you, please.
Can Professor check now?
Yeah, she's a co-host.
I'll try again. Yes, now I can. Thank you. Great. Well, good morning. It's my pleasure and my honor to be part of this important discussion. You know, I think it's really so relevant and so valid that Parliament is also engaged in these questions of how to monitor children's rights fulfillment in the South African context. So this is a very welcome development. So everybody has already spoken about the fact that South Africa has ratified the Convention on the Rights of the Child. That was back in 1995. It has also been mentioned that compliance with and implementation of this convention is overseen by the Committee on the Rights of the Child. There are 18 members of this committee, and they are put forward by their states parties and voted in by the states of the United Nations, so that it is broadly a representative committee. But once the committee members are there, they are considered to be independent. As you know, I am currently one of the 18 committee members. The convention requires states to report 2 years after ratification and then every 5 years thereafter. And South Africa reported in 1997 and then again only in 2016. So there was a very long gap. I think the whole situation then was that they combined a few together, but it is called the second report, and the next report is going to be combine the third, fourth, and fifth reports. I do see that someone has raised their hand. Do I need to pause so that can be dealt with?
Let's continue for now, and then we address issues after your presentation, and thank you. Okay. The reporting cycle, and it's quite important to think of it as a cycle, is generally, done following the receipt of the report from the state party. So the state party sends in their report, and then the committee also receives alternative reports from UN agencies, from the South African Human Rights Commission, and from civil society organizations as well. At the end of the report having been presented, the committee issues concluding observations in which it provides recommendations to the state party. And the state party is supposed to then act on these recommendations to improve compliance and implementation during the 5-year reporting cycle. And in subsequent reports, it is expected to show how it has improved things. Now, that is the standard way where the committee receives a report from the state party first. But in fact, there is also something called the simplified reporting procedure. And this was open for states parties to opt for, and South Africa did opt in to the simplified reporting procedure. So the first step of the process under this new simplified reporting system is a list of issues prior to reporting, which the committee summarizes to the LOIPR. And in March 2021, the CRC committee issued a list of issues prior to reporting to South Africa. And in the rest of this presentation, I'm going to focus on what's contained in the list of issues prior to reporting. But obviously, I'm only providing the highlights, but just to show you what kinds of questions the committee is interested in hearing reports about. So I'm now moving from the procedural to the more substantive. So first of all, the committee asked, what are the new developments? Please provide information on measures taken to ensure the protection of children's rights in the context of COVID-19. So it's quite predictable, right, that the committee would want to know what's been happening lately with regard to COVID-19, and also what happened, and also what have you done to mitigate the adverse impacts in view of the statement of the committee in April 2020. So when the COVID epidemic first came out,
The Committee on the Rights of the Child, as many other treaty bodies, issued a statement guiding states parties and saying, please make sure that children's rights are still upheld during this period and that you take special measures and so on. So the committee is now asking what was done in respect of that. Also, the committee is asking about what evidence can you show about child rights-based approach for the fulfillment of the Sustainable Development Goals? So the committee is requesting particular information on this, showing how a child rights-based approach is integrated into the planning, implementation, and monitoring of measures to achieve the Sustainable Development Goals. I think South Africa probably has quite a lot to be able to say about that, because of course under the National Development Plan, there was a child rights participation process. So that's the kind of thing that the committee will be looking for. And they're particularly interested in the participation of children and data collection and how such measures promote the realization of children's rights under the convention and of course under the first and second optional protocols. Then it moves on to more general measures, asking the government to explain what measures it's taken to fully incorporate the provisions of the convention into the domestic legal system, including national legislation through such acts as the Children's Amendments Bill. So the committee is aware of the Children's Amendment Bill and is asking specific questions in relation to that. So you can see, I think, here where the legislature's role also is very clearly flagged by the committee. It also asked what measures have been taken to conduct an assessment of the extent to which the national legislation and practices comply with the convention, and also and this has been mentioned by a few speakers as well, but it's very important. What measures have been taken to ratify the optional protocol to the convention on a communications procedure? So this is an individual communications procedure which would allow children to be able to bring communications to the committee. However, one must understand that that is only after they have made an attempt to exhaust the domestic remedy. So it doesn't mean they can come straight to the Committee on the Rights of the Child. They first have to try resolving their issues through the Human Rights Commission, or through taking cases to court locally. And if they can show that they've tried to do that and they didn't get anywhere with that process, then only can they come. So I think if Parliament is interested, we could certainly provide more information on this optional protocol. Government has indeed been working on it, and the previous speaker mentioned that there was that DIRCO hosted a special day on this optional protocol in order to discuss it, and it is certainly looking very positive at this point that there will be accession to this treaty, but again, Parliament will play a role in that aspect. The committee has also asked, what about policy and coordination? They want to know what's being done to make sure that all national policies encompass the convention, also to amend the medium-term strategic framework of 2019 to 2024 to include children as a national priority, and to implement a revised national plan of action, and to ensure that the newly established Office on the Rights of the Child has the mandate and adequate resources to fulfill its leadership and coordination role. So you can see that the committee is also interested again in how is government coordinating its activities? Is it working intersectorally across different departments in order to fulfill the rights of children? So we have already had some things mentioned today about how important this is going to be, and this is something that will be high on the agenda in the dialogue when the government comes to report to the committee. The committee is also asking about allocation of resources, and as we know, this is also something that the legislature plays an important role in. So here it was to ask is the state party incorporating a child rights approach to budgeting? What has been done to eradicate corruption and to ensure a transparent, accountable, and participatory budgeting process? So there's no shying away from the realities that South Africa has gone through a process of uncovering corruption, and that, you know, this obviously is important, because any country that is not fully accounting for its resource allocation is not able to deliver properly on its mandate. To ensure that children are not affected by regressive measures taken in response to the COVID-19 pandemic and the potential consequences of the economic crisis posed by such measures. So what we heard last week on the 16th, all of those facts and figures about the multidimensional poverty and the fact that COVID is going to further impact on that, the committee is definitely going to ask questions relating to that, and will want to hear what is planned to offset some of those harms, and how can we be sure that children's rights will not regress, particularly when it comes to economic and social rights. Data collection is another thing that the committee wants to know about. What has been happening to improve data collection and to collect disaggregated data relating to the implementation of the convention generally, but the committee flags, what about data on child victims of violence, sexual exploitation and abuse, and on children in disadvantaged or vulnerable situations, including children with disabilities? So the committee is flagging particular groups that it wants to hear data about. And then also to make sure that data is collected in a coordinated fashion. We know that this is a long-standing difficulty and problem, that the different departments' data doesn't always speak to one another, but this is something that the committee will look forward to hearing if there have been improvements about. Now, although the committee itself has a monitoring role, it also wants to know what is happening as far as monitoring of children's rights is concerned at the national level. So it's asking in particular, what measures are taken to provide the South African Human Rights Commission with sufficient resources to receive, investigate, and address complaints raised by children, and to provide the commissioner responsible for children's rights, that's within the South African Human Rights Commission, but also it might be interesting to hear about the Western Cape's Children's Rights Commissioner. What is being done to ensure sufficient resources to guarantee the effective promotion and protection of children's rights? Because South Africa has not decided to have a specialized children's commissioner at the national level, the focus is on ensuring that within the South African Human Rights Commission, there is a proper, professional, dedicated commissioner with the proper support around that person. The Committee on the Rights of the Child doesn't demand that there must be a specialized children's commissioner or children's ombudsperson, although many countries do have that. But if that is not the case, then the committee asks some probing questions, because we know that children's rights often get lost when they're in a broader framing like a Human Rights Commission. Other substantive issues that are raised in the list of issues prior to reporting, I'm not going to go into any detail, but just to show you what the committee has flagged as being particular issues that we're interested in from South Africa are environmental issues, the role of the business sector, pollution, climate change, very much on all of our minds at the moment, right, because of COP, but also a rising issue in South Africa. And there's going to be definitely questions asked about this big new deal that the government has obtained. Where are children in that? And then another issue that the committee has flagged before and will want to hear about is the harmonization of the ages of marriage. violence against children, domestic violence, and corporal punishment. And in the list of issues prior to reporting, the committee particularly asks about the Freedom of Religion South Africa case, which did away with the defense of reasonable chastisement. And the committee is asking what's been done to bring the law in line with that, because although the defense was declared unconstitutional, what more needs to be done and what more is being done to make sure that there is a comprehensive approach, including through, of course, the Children's Amendment Bill. What about family environment and alternative care? What's being done there? Children with disabilities, the need to develop a comprehensive law and policy. And the committee asked a lot of questions the last time about inclusive education and the rights and needs of children to be included, because so many children in South Africa who have disabilities are not actually included in the education system at all, let alone in the mainstream system. Healthcare and services to children, and just overall standard of living issues. So this would be about poverty in households and the grants and what the plans are around all of that. Education clearly on the agenda, including, of course, early childhood education and development. Children in situations of migration, which probably doesn't get enough attention, is my feeling. I think the committee will definitely want to know more about that. The administration of child justice and what's happening in that sector. And then, of course, also child victims and witnesses of crimes. So those were the substantive issues, and those are all of the what's coming through in the list of issues prior to reporting, just a very quick overview. And I'm moving back now to the procedural issues. So in some ways, the CRC monitoring process and all the information that is exchanged between the executive and the committee is an opportunity for Parliament in its monitoring role. So there's a huge amount of information that is shared between the government and the committee, in other words, by the government to the committee. And also many civil society organizations report and often make their reports public as well. So all of that information would be very useful for Parliament to peruse, to see, okay, so what is government actually reporting at the international level, and what are they promising to do? Because if so, we at Parliament can perhaps hold them accountable on what promises they have made. So that's one thing to think about. And then the other thing is, of course, that some of the recommendation is right within the purview of Parliament's own role: legislation, budgetary oversight, and of course, holding government accountable. The vast majority of recommendations must be carried out by the executive, but we must remember that the legislature has oversight of all of those activities. And so one can really see an opportunity for symbiosis in the oversight role that the Committee on the Rights of the Child plays and Parliament, because the information that comes to the Committee on the Rights of the Child is also available to be considered by Parliament. So that brings me to the end of my presentation, and I will stop sharing. Thank you very much for the opportunity.
Thank you so much, Professor Skelton. This was extremely informative, as to explain to us what are the reporting obligations to the Committee on the Rights of the Child in regard to the implementation states of the Convention on the Rights of the Child, and the upcoming list of issues, but also expectations that the committee will have on the South African government to respond to, and the role of the different partners in the reporting process. So thank you for your time and leadership, as always, and insight. I'm happy to hand over to Dr. Wesso to introduce Honorable Zoe Nodongeni. Over to you, Wilbert.
Thank you, Micah. And ladies and gentlemen, it now gives me great pleasure to introduce our next presenter, who is a member of the Select Committee on Health and Social Services in Parliament. We do realize the busy programs of senior politicians at Parliament, and unfortunately, Honorable Gillian, the chairperson of the Select Committee, could not make it due to other work commitments, and she sent her apologies. However, Honorable Ndongeni, who is a member of the Select Committee, kindly agreed to stand in for Honorable Gillian. She will present on the role of Parliament in strengthening the national system of child rights governance and driving improvements in development outcomes for children. With this brief introduction and in the interest of time, over to Honorable Ndongeni.
Thank you, Chair. Thought about that. Thank you, Chair. My name is Nokuzola Ndongeni. I'm serving in the Committee of Health and in Select Committee of Health and Social Services. I'm a member. Thanks about that. Let me quote to our Tata Nelson Mandela, former President of Republic of South Africa. Open quote, "The true character of a society is revealed in how it treats its children," close quote. The first democratic president of Republic of South Africa recognized the importance of children and their rights. This quotation should resonate with all of us and should inform the work that we do, not only as parliamentarians, but also as a member of society, for the betterment of our nation, for greater good. Democracy in South Africa came with a growing recognition of children's rights and the establishment of high-level structure to meet government's responsibility. Section 28 of the Bill of Rights in our Constitution, 1996, states that every child has the right to basic nutrition, shelter, healthcare, and social services, as well as the right to be protected from maltreatment, neglect, abuse, or degradation. Some of the obstacles to achieve these rights comprehensively are adequate resources and system to implement laws such as the Children's Act, Child Justice Act, and Sexual Offense Act fully. The need for the reflection of the children's rights and government originated in the realization that children's rights could not be significantly advanced without close consideration of the government system in which they are implemented. Implementation of the Convention on the Rights of the Child is highly dependent upon the way traditions, mechanisms, processes, and institutions through which authority is exercised, operating for common good, not only for children, but also for all. Conversely, government can only be comprehensive if it takes into account the human rights of all. This includes children. Governments rest on a series of principles, which may vary, but generally included transparency, responsibility, accountability, participation, and responsiveness to the needs of the people. These elements also underpin the development of a framework of the linkages between government and the children's rights. Parliament is the central institution through which the will of the people is expressed. Laws are passed and government is held accountable. It is essential that the South African parliamentary continues to engage government departments, national and provincial, and the civil society organization to achieve sustainable results for children, whether related to education, health, safety and security, protection from viruses and disease such as HIV and AIDS, and provision of nutrition, water and sanitation. That as a parliamentary, we have the power to create a real and lasting change for children. Parliamentarians can allocate resources from national budget, establish strong policy direction and debate, shape the enforce law that protects children. They can also ask tough questions, monitor implementation, and hold governments, industries, and civil society accountable. When parliamentarians speak on behalf of children, their voices resonate. As parliamentarians, we are unequally positioned to send the message that the well-being of children is the responsibility, not for just of people who work with children, but also of all society. Research demonstrates that sustained structural, technical, and advocate support is needed to equip parliamentary champions with sufficient information and confidence to drive necessary changes. Strong leadership facilitation parliamentary action that drives change towards improvements in development outcomes for children. Parliamentary champions of development outcomes for children are essential for building sufficient political will to pass the necessary laws, budget, and policies. Structures such as caucus and cross-party parliamentary groups can support parliamentary leadership and objective decision-making by providing a platform for information exchange, joint planning, and strategizing. They often work to depoliticize controversial issues in a political charged environment, transcend political party dynamics, and thus achieve broad ownership. These groups undertake, advocate, and effectively maintain momentum for children's rights. By leveraging partners, knowledge, and capacity, multi-stakeholders partnership can effectively increase parliamentarians' access to data and capacity for children. Hence the importance of the work of and relation with Unicef. The partnership can also create an able environment for parliamentary action by working with the media, creating a citizen movement, and advocate for political leaders. However, more needs to be done to support national parliamentary engagement in driving improvements in development outcomes for children. Given the potential improvement that parliamentary action can bring for improvement development outcomes for children, increased predictable, long-term, and flexible funding from government and development partners is needed to support such parliamentary engagement. Multi-stakeholders partnership operating at the level should include parliamentary and consider parliamentary perspective with a view to facilitating and supporting their action for improvement in development outcomes for children. Parliament, through its committees, should be champion in driving improvement in the development outcomes for children. These could be achieved through 1, investment in promotive and preventive intervention, particularly those with the proven ability to achieve immediate development benefit for the child and long-term benefit for the sustained development of the country. This includes investment in early child development service to build sound foundation, and in the continuation of ongoing family and community-based support to sustain nurturing, environmental, and network through the life cycle of the child. Prioritizing parental support and family strengthening initiative as development and protection start and are sustained in the home. Ensuring that development outcomes of the children are promotive and provide universal platform of public service to support and promote the development of all children through the realization of the rights. Ensuring the government departments and those working with children create supportive, safe, and able space in families and community, as well as in facilitating an institution for nurturing the responsive relationship and care. Ensuring that children at risk of neglect and abuse are offered targeted, appropriated, and additionally early intervention service to protect them from the abuse, neglected, and exploitation. These services must build the resilience of vulnerable families and children to enable responsive and nurturing caregiving relations that can ensure the development of children to their full potential. Putting effect and strong child protection system and procedure in place for the early identification of children who lack family care, experience abuse, neglect, and exploitation, and or are exposed to the criminal justice system. Ensuring the provision of the responsive protective service to the children, families, and caregivers to protect the children from further harm, limit the impact of the circumstances on their development, and secure their placement and return in permanent responsive caregiving relationship, preferable with their families. Advocacy through the parliamentary caucus should be reinforced, and formal parliamentary institutions should be supported to be more responsive to the need of children and adolescents. Parliamentary must be supported to increase female representation while ensuring that women members are informed, capacitated, and supported to address improvement in development outcomes for children issues. In conclusion, Chair, support for parliamentary action must be accompanied by efforts to inform and empower citizens to progressively demand their rights and to give voices to affected communities, including the use of digital information and communication technologies, whilst considering the different contexts children in South Africa live in. As parliamentarians, may we be steadfast in fulfilling children's rights, holding the executive to account for what they have or have not done, and work alongside other partners to promote and defend the rights of the children. I thank you.
Thank you for your presentation, Honorable Ndongeni. I think it was very informative and gave us much food for thought, especially from a parliamentary point of view. I think in terms of highlights, I think the quote from former President Mandela is very relevant and highlights the importance of how we treat our children. I also agree with the honourable member that the values of Parliament in terms of responsibility, accountability, etc., is of paramount importance in this regard. Honourable Member Ndongeni also pointed out that there is room for improvement in enhancing child rights governance in Parliament, and we certainly need to follow up on that. Honourable Member, we appreciate your time in your busy schedule to attend this webinar. I now hand over to my colleague again to introduce Ms. Zita Antungule. Thank you.
Thank you, Honourable, and thank you for preliminary commitments towards the realization of children's rights through parliamentary structures and strengthened systems within Parliament. Thank you, Dr. Wessel. Hereby, I have the pleasure to introduce Ms. Zita Hansangule from the Center of Child Law, where she first was a student assistant in 2011 and now became part of the Center's research, monitoring and evaluation team. Ms. Hansangule holds an LLB degree and a master's degree in child law and is currently working on her doctorate on children's rights. So how more pertinent can that be for this morning? She's been involved in a global study on children deprived of liberty and a study on the impact of the Child Justice Act in South Africa. We have 25 minutes for both Ms. Hansangule and Mr. Modikwane. I will introduce Emmanuel after you have spoken. Over to you, Ms. Hansangule. Welcome.
Good morning, and thank you for having me. Let me just share my slide quickly. Okay, can you see that?
Yes, we see you.
Okay, thank you very much. Yes, as I've been introduced, my name is Zita Hansangule from the Center for Child Law. I am part of the Center's Research, Monitoring and Evaluation Unit. I have been asked to give a presentation on civil society's role in addressing challenges faced by children during a pandemic. And this is very pertinently linked to the discussions that we've just had before, where we've been talking about responsibilities coming out of international human rights, as well as responsibilities placed upon Parliament. Just to give a brief background on the status of civil society in South Africa. Generally, civil society is a wide array of non-governmental and not-for-profit organizations that have a presence in public life, expressing the interests and values of their members or other communities. So this would include your community NGOs, your advocacy groups, your litigation organizations. And in the context of children, these are organizations that work with children on the ground in the communities, organizations that do research on children's rights, and organizations that do litigation on children's rights. South Africa is a constitutional democracy in which social movements, social justice activists, and civil society have spaces in which to express their voices in respect to systemic challenges, barriers, and concerns that are expressed and faced. Again, this applies to children, as you will see as the presentation goes on. Civil society takes on a number of causes that are relevant to the lived experiences of vulnerable groups like children. And they work collectively or individually to make use of platforms available to them to ensure change and make sustainable impacts in children's lives. So part of the work that we do is awareness raising, lobbying, engagement with duty bearers like Parliament, protest action, engaging in parliamentary processes for law reform, and engaging in the courts for judicial redress. Now, a lot of this work was seen during the COVID-19 pandemic, and when civil society actors came to the fore as frontline responders and defenders of children's rights and human rights. The role of civil society actors is more pronounced in a pandemic when the unknown arises and quick responses are required from government duty bearers. Civil society organizations are in a unique role to be able to note the impact of sometimes quick responses, and are able then to put these impacts to the fore and safeguard the rights and well-being of vulnerable groups such as children. Part of that work includes providing basic needs. The COVID-19 pandemic showed that pandemics of this nature often require emergency responses to prevent rising infections. Unfortunately, sometimes these responses also have the risk of resulting in rising needs, especially for groups such as children and people left without the regular incomes. And these rising needs, you will see, is in relation to access to food, access to healthcare, access to social grants. And civil society often plays the role of filling the gap left by the state or private actors, and this is oftentimes conducted in cooperation with the state or private actors, where we come together, state, private actors, and civil society, to say we have noted this need faced by children, their lived realities, and this is how we're going to meet these needs. And this could be access to food. This could be access to care and protection services. This could be access, other sort of support to families and communities who are struggling under the strain of a pandemic or the strain of everyday life, even before a pandemic or after a pandemic. Next is advocacy. So civil society organizations carry out a lot of advocacy work, and this is again seen with a pandemic, where you see shifting priorities, repurposing of resources, and accelerating policy development to meet needs and emergencies brought about by a pandemic. And again, this is work that happens even outside of a pandemic. Civil society actors are able to identify gaps in policy and service provisions that could have a concerning impact on vulnerable groups such as children, and advocacy is used to address these challenges, barriers, and gaps, also create awareness amongst those who are impacted about their rights and the services that they are able to access. And I put up an example of such advocacy that came up last year during the height of the COVID-19 pandemic, where we realized that because of loss of jobs, there was a need to boost grants, particularly the child support grant, that was not only meeting children's needs, but the needs of the families that the children lived in as well. So there was a lot of advocacy happening around there by civil society organizations working in collaboration with each other, and pointing out the needs and how the child support grant, a boosted child support grant, would support those in need and those facing things like food insecurity. The next work that is conducted is providing services remotely. So as civil society organizations, used to going out into the community, used to meeting people in our offices or in the spaces where they are, had to now adapt, had to find ways to still be able to provide our services. So we had to expand the provision of services online or on the phone, so that because we couldn't do it in person. And this pointed to the growing need to use online spaces. And again, this is an example of where particularly litigation organizations, who often every day we receive phone calls, messages with people requesting advice. We had to say, we are still here to assist you, we are still here to help you, even though we are in level 5, level 4 lockdown. And then lastly, work that is carried out is litigation. So recognizing the need to ensure access to justice for the vulnerable is key in ensuring oversight and accountability by duty bearers and securing the rights of those who are left behind during a crisis such as a pandemic, or left behind in other ways and other spaces. Litigation organizations in South Africa play a role in ensuring that the rights set out in international instruments, such as the Convention on the Rights of the Child, and the well-being of children in South Africa are protected and advanced. This is no different during a pandemic, and this will be seen in examples of litigation that happened in 2020, again during the height of the COVID-19 pandemic. This is the first one. This matter never went to court, but one of the things that was noted by two organizations, the Center for Child Law and the Equal Education Law Center, was guidelines on children with disabilities who had to go back to school when school started opening. So we had education guidelines that were put out by the Department for Schools, but when we studied them, we saw that these didn't really meet the specific needs of children with disabilities. Engagement occurred. It didn't yield the required results. Therefore, processes for litigation started, and we eventually ended up settling with the department, and guidelines were reviewed and created specifically to meet the needs of children with disabilities. The next example I give is access to the National School Nutrition Program. And this is a matter dealt with by Equal Education in Section 27, again, where schools were closed. And this meant that children who were accessing the only food through school nutrition programs could not access the food. Therefore, litigation had to be instituted to reopen the National School Nutrition Program. I think that's the end of my presentation, and just a brief overview of the work carried out by civil society organizations within a pandemic and generally outside of a pandemic to ensure the protection of children's rights and oversight of child rights governance. Thank you very much.
Thank you very much, Ms. Hansangole. This was an incredible, rich presentation and sweet and short, demonstrating to us the invaluable importance of the role civil society plays in terms of advocacy, as well as complementary role to the state in service provision. Like you demonstrated during the closure of the schools and school meal program, civil society played a tremendous role with soup kitchens and food parcels, as well as with PPE support. So then the role you play in terms of litigation is incredibly important too, in order to really make sure that children and their rights are being brought to the fore and addressed at critical times at all times. So thank you so much. I now have the pleasure to introduce to all of you Mr. Manuel Modikwane. He is the Child Rights Program Manager for Save the Children but also a member of the executive board of the National Child Rights Coalition in South Africa, which has been recently established. He was instrumental in the completion of the National Child Participation Framework, primarily to ensure that children influence in the decisions that affect their lives and that their voices are amplified for the realization of their rights. Emmanuel, it's our pleasure to introduce you and welcome you, and over to you. Thank you so much.
I don't hear sound.
That's better. Okay, thank you. So South Africa is committed to realizing children's rights, and especially for the most vulnerable, it is essential for that is essential for ending poverty and inequality. On the other hand, only once we've ended poverty and inequality can we really realize children's rights. So fulfilling these duties requires focused child rights governance, which is a statewide in partnership with all its development partners and children themselves. Recognizing children's rights as key to breaking the intergenerational trap that has been spoken to by the Honorable Member of Parliament and all other colleagues. That is quite important and essential in this instance. Children's rights governance requires that children's rights are at the center of all decisions and are advanced within that space. So what that tells us this, children's rights, we have to think them across the planning cycles of our state, whether it's in municipalities, in provinces, at national, throughout the 5-year planning cycles that we have, at different branches of government, at different spheres of government. And also, much more importantly, we need to begin to strengthen particularly the tier of the sphere of government that is local and in relation to the now introduced district development model. So what is governance? So before we try and unpack the governance challenge, let us agree on what we mean by this. So for us, it refers to the set of decision-making, allocation and use of resources, and monitoring and accounting for their use to achieve the shared goals and priorities of our communities and nations. So that is our starting point as the coalition. That's how we define it. And in our case, the shared goal is development through the realization of children's rights. The community is the statewide collection of role players with responsibilities to realize children's rights and development. So when we talk in this sense, when we say statewide, we don't necessarily relate to government. We're talking about civil society, business, and so forth, and even individual activists and children themselves. Governance processes are organized in a system governance. The challenge is to have in place a national child rights system that can effectively align, direct, and coordinate all governance processes of all the role players to achieve the common goal, which is realizing children's rights to achieve development. So that is core, and it's not foreign to what we've been hearing other colleagues talking to. So we think South Africa is at the crossroads. Decisions made now in terms of priorities and what we invest in will determine how we recover from COVID-19 effects, as Zita had articulated them, get back on track to achieve NDP, SDG, and plan of action goals articulated in all these documents. Eliminate poverty and inequality along equity fault lines as race, gender, geography, disability, and so forth. So we are at the crossroads in relation to these things. And the decisions that we really make at this point are going to really affect how we move forward. So how well are we doing? We have clear policy recognition and commitment to nurturing care as the foundation of sustainable human capital for inclusive development. And the Deputy Country Rep spoke about that earlier on, and we recognize that fact. We have seen significant increase in budgets to some key services, such as health, education, and ECD, even though in the presentations last week we could see significant gaps that are there in terms of ECD and education. So spending more, but outcomes are deteriorating. So pre-COVID, 60% of children with most marginalized were not accessing the required services. So COVID has also exposed some of the challenges and gaps that we have in our society in relation to realizing children's rights. 38% of under fives are at risk of poor development and stunting increasing. So almost now we should be at about around 30% in relation to that. So what are we saying here? We're saying Parliament, and how can Parliament play its role within the child rights governance cycle? This is not quite, the letters are small, but I will talk to some of these things. And I'm glad that even Prof. Skelton spoke to some of these things in relation to the list of issues prior to reporting, which I'm glad to say that the coalition was quite instrumental in making a submission to the committee using this simplified reporting procedure. So we're talking about treaty ratifications, development, that is within this continuum of government, the role that the child rights governance continuum, the role that Parliament can play. So a lot of colleagues have spoken about treaty ratifications, the development and adaptation of laws that Parliament plays central role, development of strategic and annual performance plans to fulfill legal mandates, development of programs to implement laws and policies, allocation of resources, and use of budgets for implementation on those plans. Development of human resources and infrastructure for the implementation and realization of children's rights. Monitoring and reporting to Parliament, to Human Rights Commission, to treaty bodies, that's quite central as well. Follow up on concluding observations and recommendations from several treaty bodies, the AU and the UN, that's important. Critical is how can civil society interface throughout this continuum to support and work together to mutually reinforce each other in meeting these obligations and making sure that this child rights governance continuum helps to fulfill and deliver child rights. So at each point, we need to have conversation as civil society to support these processes in the continuum. So, suggested way forward and recommendations. So specifically, we would aspire to establish that Parliament establish consultative policy and budget dialogues for developing coherent child-centered policy and short-term priorities. We had also, when Prof. Skelton was presenting, that we need to, the committee wants to see how far are we doing with our child-centered approach on policy, on budgeting and all these things. So this is quite important. So if we can establish that consultative dialogues, not with civil society and with children. We need to strengthen human resources for child-centered development, planning, provisioning, and monitoring. So if we want to help to be this capable state, we need to seriously look at the capacity of our human resources. So we need to strengthen that, and civil society is ever willing to play some role in enhancing that space. Strengthening systems to ensure adequate allocation and efficient use of public resources to implement priorities. So questions of efficiencies, effectiveness, they are quite important. And we need to see, with limited resources that we have, how best can we use them. Sometimes we don't necessarily have to have new money, but we can use the current money strategically and effectively to achieve the outcomes that we want. And in this instance, that cuts across provinces and municipalities. And we've been hearing from the Auditor General some of the problems that we have with municipalities and all that. So that needs to be strengthened as well. We need to strengthen accountability mechanism for resourcing of national priorities. I mean, almost everybody, we seem to be agreeing, but the question is now where to. We need to establish proper these accountability mechanisms and even strengthen those that are already in place. So, So we also need, we need to develop and use a shared national child rights monitoring and reporting follow-up framework. And currently we are developing it to measure progress against shared goals, to monitor, hold accountable and report across operations of both entities. So civil society and the state, we need to develop this framework for us to be able to monitor these outcomes. And that relates to, the treaty reports that colleagues have spoken to and all that. We need to support participatory processes with children and beneficiary communities. And one of the things that we can begin with is to constitute the National Children's Parliament as one of the sectoral parliaments, because we've got the men's parliament, the women's parliament, but we don't have the children's parliament as a sectoral parliament. We need to institutionalize our partnership through MOU with Parliament on all its supporting institutions in this instance. So that becomes critical for us, that we want to ensure effective institutional mechanism for long-term leadership, coordination, especially adequately resourced and capacitated ORC across all spheres of governance to ensure aligned child-centered budgeting and programming. So that becomes critical for us. So thank you very much, and we appreciate the opportunity offered.
Thank you very much, Mr. Modikwane, for your time and commitment this morning to explain to us again what is the definition, what is this child rights governance, and as well as what is the interface between Parliament and civil society, and how can we strengthen and deepen this collaboration between Parliament and civil society. So also calling for an MOU with Parliament, between the coalition and the Parliament, in order to ensure that this interface and collaboration is further strengthened in the various roles that Mr. Modikwana so ably lined up for you. Thank you, Mr. Modikwana, once again. I have the pleasure to introduce to you Ms. Patricia Martins. She has done magnificent work as a consultant for Unicef and as a senior expert in child rights governance, working with various institutions in designing all of this work with us in partnership with so many Parliament, South African Human Rights Commission, Civil Society Coalition. And I have the pleasure to invite her to moderate a few questions and answers live, please, before we come to the further closure of this morning and the way forward. Patricia, over to you. Thank you.
That I just share a couple of contextual points which really provide the context for the questions that I'm going to ask, and that pull together the presentations and a critical theme that ran throughout the presentations that were presented this morning. What we really need to ask and answer in the context of our treaty obligations as a country is, what is it that we actually are committing to do? We ratified all of these treaties some 30 years ago, and we do need to remember that actually what we have agreed to do in terms of our commitment, not to realize all of these individual rights and take all these governance processes, those are a means to an end. What we have agreed to do is to secure that every child in South Africa doesn't only survives, but develops to their full potential. And that is the big picture, and that is our big commitment that we have committed to, and that is our responsibility. It's a legal contract that we have entered into with the treaty bodies, with the UN structures. And the challenge is that so often when it comes to our treaty obligations, we lose sight of what we actually have committed to do, because what we then have committed to do is to orient our entire governance system to realize it is on. Sorry. What we've committed to do is to take those treaty obligations and to embed them into our entire governance continuum to realize children's rights so that we can see every child develop to their full potential. So let's take, for example, the situation of if you contract as a contractor to build a pool, your obligation is not to report on building the pool, and it's not to report on having found money in your operational budget or to buy the right sand. If at the end of building that pool, you can make all of these reports, but the pool leaks or the pool starts cracking, we then have a situation where we fail to fulfill our treaty obligations. And sadly, that is the situation that we're facing in South Africa at the moment. We've committed to ensure the equal and optimal development of every child, yet the children will only develop to 48% of their potential. And when we look at this, look at the state as a parent. As a parent, we're probably all in this room being parents or going to be parents. We don't sit down and say, okay, we will give our child toilets and we will make sure that they have access to education or clothes. We make sure that children have the full package that they need to thrive and develop to their full potential. And that is the responsibility of government. But that's where the challenge comes in, because we have this complex structure that needs to place children's development at the center and have all of our role players understand what is necessary in combination to realize that development. And what we are looking to structures like Parliament and civil society to do is to keep their eye on the big picture and hold us accountable as a state for realizing the full development of children. The questions that we have already been anticipated in some of the comments and questions, in the sense of what are we measuring as a country? What are we holding ourselves accountable to? And how then do we ensure that institutionally we hold ourselves accountable to realizing the full development of children? How does Parliament shift from its current focus, and it's not just Parliament, it's across government that we have the situation where we have in
question is, our treaty obligation is to ensure that every child develops to their full potential. How do we ensure that Parliament, as a fundamental state institution, monitors that overall outcome and does not fall into the trap of monitoring, are we reporting, and monitoring individual isolated rights, because we've been doing that for 30 years and children's development has deteriorated. So the question is, how do we support Parliament? How does Parliament strengthen its oversight role to drive the development, to hold us accountable for improving development outcomes for children? Given that Parliament's structure is siloed, Parliament's structure follows that of government, we've got different portfolio committees. Parliament's strategic plan itself does not reference our treaty obligations. It references, in fact, the National Development Plan, and that is what a lot of the portfolio committees take their direction from. So the question is, how do we strengthen Parliament's oversight and leadership role in driving a child rights governance agenda to ensure the development of children, the improved development of children? So the floor is now open for comments, for discussions, or observations in that regard. I'm not sure if we are going to take questions. Are we going to be taking questions directly, or are we going to take questions in the chat box? 5 minutes. Kindly asking Professor Skelton to answer the question that was in the Q&A. Over to you, Professor. Thank you.
Yes. There was a question in the chat towards me asking whether I could offer some kind of technical assistance to Parliament relating to monitoring and oversight of children's rights. The answer to that is yes, I can as long as it doesn't interfere with my independence as a member of the committee. I should just mention that when South Africa reports to the committee, I do not sit as a member of the committee when they appear because of independence issues, because I wouldn't be able to be independent when it comes to my own state. I think, therefore, I can play a role like the kind of role that I'm playing today, where I'm providing information, and it could probably be more discursive than that as well, but not in a way that would in any way interfere with my independence.
Thank you very much, Professor. So we have 3 more minutes left. As per Ms. Martin's introduction, it was really for us to get some feedback from members of parliament and other parliamentary personnel in terms of the role of parliament to strengthen its oversight role, as well as legislator in terms of improving the situation of the rights of the child and child rights governance. The floor is open. See a hand from Mr. Fokwa.
Thank you so much, Mike. I think there was a very crucial question that was asked. How do we expect the parliament to strengthen its oversight role? And when we talk about the parliament, I think it's important for us to be mindful of the fact that the parliament is a very big body. So when we talk about the parliament, what are the specific portfolio committees that we are referring to? I think it is very, very important for us to identify that as well. The second thing that I also just want to add is the fact that when we want the parliament to exercise its oversight role on issues, I think it is very, very important to make the parliament to also have a very good understanding of those issues. In terms of South Africa's treaty obligation, we need to also look at whether the relevant members of parliament do have a very good understanding of the substantive content of the Convention on the Right of the Child. Do they have very substantive information on the relevant benchmarks, indicators that are supposed to be used to ensure that South Africa is complying with its implementation obligations? Those are some of the key things that we have to look at. And then the third point that we also have to look at is when we say that the parliament should exercise its oversight role. These roles may be exercised, but how are we evaluating to ensure that such oversight role is leading to any positive impact? So these are just some of the points that I would like to highlight. Thank you so much.
So thank you very much for that, John. And I think your point around the complexity of Parliament is really important. Parliament, and your question around which portfolio committees, the answer is all portfolio committees should have an intimate knowledge of our treaty obligations and understand how to advance those through child rights governance. The challenge is that the portfolio committees are broken up into isolated committees, and then many of the portfolio committees don't consider themselves relevant to issues of children's rights. So I think one of the proposals on the table is how do we strengthen coordination and leadership? It's not just an oversight function, but a leadership function of Parliament to lead and to strengthen our child rights governance system. Is it not perhaps that we need something like a children's portfolio committee that brings together all of these issues and provides leadership and coordination as well as oversight as an institutionally strengthening mechanism within Parliament, Yes, civil society and research institutes can come in and we can support Parliament, but Parliament itself needs to reflect on its own institutional arrangements and how it strengthens its child rights governance system. Thank you.
Thank you so much, Ms. Martins. If there are any urgent questions or delegates that would like to take the floor, please feel free, because otherwise we're going to close this wonderful dialogue and map out the way forward. So the questions that have been put in the Q&A will be addressed by members who attended this webinar in a written manner if they haven't been able to be addressed yet live. So without any further ado, I would love to welcome our representative, Ms. Christine Muhigana, who has been there with us also last week as to be welcoming us for the first webinar series. Ms. Muhigana is a national from Rwanda and our representative in South Africa, as she was in CAR, Central African Republic, as well as Deputy Regional Director in West Africa. So we are welcoming you, Ms. Muhigana, over to you to share with us what is now the way forward after we had these most insightful first two webinars with members of Parliament personnel, as well as stakeholders from wide in society. Over to you, Christine. Thank you.
Thank you very much, Michael, Ms. Hobrex. Can you hear me?
Yes, very well. Thank you.
Thank you. It's been such an honor and a pleasure to listen to the deliberations of this morning's session, such insightful and high-level participation. It's really rewarding to be part of this very important exercise, and I want to thank everybody who's been involved in preparing and delivering it. So to the Speaker of the National Assembly, I understand she's not with us, but I'm greeting her anyway. The Honorable Chairperson of National Council of Provinces, possibly also in absentia, the chairpersons of the Portfolio Committee on Social Development and the Select Committee on Health and Social Services, dear colleagues and partners. A very good afternoon to all of you. I am really, as I said, delighted to be with you once more. I was with you on Monday afternoon, and it's great to be here as we conclude these two productive days that we as UNICEF, my colleagues and myself, believe really represent the start of a collective process for achieving transformation for the well-being, for the realization of children in South Africa. As was already alluded to by my colleague Muriel at the beginning, Madam Speaker had noted at the start of this webinar series that apartheid had created deep structural damages to the very fabric of this society, which then resulted in intergenerational patterns of inequality that have, despite progressive policies and political will, served to keep too many children still trapped in poverty. To undo this damage, we must break the intergenerational patterns of deprivation to build sustainable, inclusive human capital for development. And this requires that children be supported from conception until they exit childhood at the age of 18, while receiving the nurturing care they all need to develop to their full potential. In addition, Their parents and caregivers need sustained, quality, multi-sectoral support and services to enable them to provide the nurturing care to children. We have come together over the past 2 days in recognition of this and of the fact that we need to work structurally and deliberately to ensure that our governance system delivers on the support and services children and families need to realize their developmentally critical rights. It is heartening to see your commitment to ensure that children and families receive the required combinations, the required interventions to disrupt, to break the intergenerational legacy of apartheid by ensuring equal and optimal development for the full potential. Unicef, so the United Nations Children's Fund, in partnership with other UN agencies, some of the colleagues were with us this morning, and other key partners from the children's sector, we are all together committed to supporting Parliament across its full range of functions, legislative, oversight, and participatory work to maximize existing strength and address some of the challenges acknowledged over these discussions. This would include facilitating or continuing to facilitate access to regular, updated research on child rights governance, as well as providing capacity building and technical support to parliamentarians to review the budget through a child rights lens. We are confident that this would also directly contribute to strengthening coordination among multiple portfolio committees and support structures towards a reinforced child rights governance. We also look forward to working together to ensure that the issues raised by treaty bodies, the South African Human Rights Commission, and the courts are addressed in the country's planning, frameworks, and as well as the programs. In doing so, we can collectively ensure that laws are developed through inclusive, participatory processes to address the greatest risks to the nurturing care that children of this country need. I conclude by thanking you once again for the commitment to advancing the child rights transformational agenda and very much look forward to our ongoing engagement. Thank you.
Thank you very much, Ms. Muhigana. Over to you, Dr. Wessel.
Thank you, Ms. Muhigana, for elaborating on the way forward. I think in terms of highlights, you have pointed out that too many children are trapped in poverty. That is a very important observation, and children must be supported all the way before they reach adulthood. They need to be provided by nurturing them. And I think Parliament can play a pivotal role in addressing the challenges via multiple portfolio committees. The research unit within KISD will continue to work with Unicef and other interested stakeholders to continue future webinars. I'm excited about this collaboration, and it will certainly build capacity among members in Parliament. So this brings us to the end of the second Unicef Parliament webinar for the year. And as you know, there are lots of work, arrangements, organization, negotiations, and communications that happens behind the scenes to ensure the smooth running of a webinar such as this. After the first webinar last Monday, I have thanked the various supporting groups and teams. Today, in closing, I wish to highlight a few individuals. However, the risk is by doing so is that you might leave out some names, so please bear with me. We were very honored to have secured the availability of the Executive Authority for the opening and closing remarks, as well as the chairperson of the Portfolio Committee on Social Development and the honorable member of the Select Committee on Health and Social Services. A special thanks to the Acting Secretary to Parliament, Ms. Chawa, and Mr. Kaso, the Acting Deputy Secretary for Business, for their leadership and guidance in securing the relevant speakers in Parliament. The political direction and commitments from our senior staff at Parliament laid a solid foundation for future engagements, which were explicitly supported and encouraged by Madam Speaker, Honourable Chairperson, and the chairpersons of the various committees. This certainly paves the way for the sustained implementation of this part of the capacity building component of the knowledge management strategy of Parliament. I would also like to express our heartfelt gratitude to Dr. Gabriel, who is our Divisional Manager of Knowledge and Information Section Division, for his leadership in bringing together Parliament and Unicef, as well as Ms. Hubrechts and Ms. Patricia Martin from Unicef, who were all instrumental in making these webinars a reality. Their guidance and contributions during this whole process certainly lays the groundwork for future knowledge sharing and capacity building initiatives. We thank you sincerely. A big thank you also to the speakers today, including Honourable Ndongeni, Ms. Malafane, Mr. Fokwa, Prof. Skelton, Ms. Asangule, Mr. Morikwani, and Ms. Mafika for your insightful and outstanding presentations. You have given us much food for thought, and we trust to have further engagement with you going forward. Then, great appreciation to the team from Parliament comprising of Ms. Matthews, Ms. Levendale, Mr. Kijinza, Ms. Scadman, Mr. Johnson, Ms. Peterson, Ms. Watson, and our researchers from the social infrastructure and social equity clusters of the research unit, who prepared some of the speaking notes. Without you, these webinars would simply not have been possible. A big thank you. To the support staff from Unicef, thank you for the arrangements, debriefings, and hard work to make this event possible. Also, without support of each and everyone present here, this event wouldn't have been possible. A big thank you to the UNICEF representative and deputy representative, Messieurs Christine Weigana and Muriel Mafika, the technical team that supported with the organization, Ms. Patricia Martins, Mr. Shiamu Mariti, Mr. Solefelo Tima, including partners from Human Rights Commission, DSD, DIRCO, religious sector, civil society, academic institutions, corporate, United Nations colleagues, and media for attending. Also, thank you to Parliament's ICT, PCS, CBS, and committees, the Office of the Speaker of the National Assembly, Office of the Chairperson of the NCOP, Secretary to the NCOP, and Secretary to the NA, who work diligently and collaboratively, often under tight deadlines and often other competing work commitments to ensure that the webinar was well organized and communicated professionally. The speaker, chairperson, and committee chairpersons were well supported in this regard. I commend and compliment each person in their teamwork, collegiality, and commitment. Please pardon me if I have inadvertently omitted the name of any colleague, and I appeal to please share our heartfelt gratitude to all involved. So although you can't hear or see us, I think we can applaud you where we are sitting. A big thank you. With this, we would like to close this part of the webinar series, and we sincerely hope to see you again at future webinars. All the best and have a great afternoon further. Thank you and goodbye until the next time. Thank you.
And thank you to Dr. Wessel.
Thank you, Micah. Thanks, everybody.
Thank you so much. It was wonderful.
Okay.
More to come. Thank you so much.
Bye-bye.